Hey everyone, I'm Matt Dolan with Dolan Divorce Lawyers, the largest family law firm here in Connecticut. And today I want to talk about something that sounds intimidating but really doesn't have to be, and that's depositions in family law cases. If you've been told you're going to be deposed and you're wondering whether it might happen in your case, here's what you need to know. A deposition is sworn testimony taken outside of court. It usually happens in a lawyer's office where there's no judge present, but there is a stenographer and everything you say is taken down word for word. Sometimes it's also recorded on video. You're under oath just like you would be in court, so your answers matter, but it's not a trial. It's part of the discovery process. It's a structured question and answer session designed to gather information. Do all divorce cases involve depositions? No. In many straightforward divorce cases in Connecticut, depositions never happen. They're more common in cases involving complex financial issues, business ownership, high income or high assets, concerns about hidden income or improper spending, significant custody disputes, or allegations of misconduct in the marriage. If a case is more complex, more contentious, or involves serious factual disputes, a deposition becomes more likely. So what actually happens during a deposition? Here's what it looks like. You sit at a table with your attorney, and across from you is another attorney. You're sworn in, then the other attorney asks you questions. Your attorney can object to certain questions, but most of the time you'll still have to answer unless your attorney instructs you not to. You can take breaks, you can ask for clarification if you don't understand a question. It's not dramatic or chaotic like it sometimes looks on television. It may last a few hours, and in more complex cases it can last most of the day, or it can go multiple days. The scope of the questions can be broad. In financial cases, questions often focus on income, bank accounts, business interests, bonuses, commissions, stock options, spending habits, debts, major transactions, or transfers of money or assets. Lawyers may also ask about alleged inappropriate spending, for example, large withdrawals, gambling, gifts to third parties, or spending related to an extramarital relationship. In custody-related cases, questions might involve your parenting schedule, how decisions are made, communication with the other parent, discipline practices, and any allegations that have been raised. And in many divorce cases, attorneys will ask about the breakdown of the marriage, which can include questions about extramarital affairs, substance abuse, mental health concerns, domestic conflict, and allegations of inappropriate or harmful behavior. These topics can feel personal because they are, but the goal is not to embarrass anyone, or at least it shouldn't be. The goal is to gather information and lock in testimony for a future trial. So why do depositions matter? Depositions serve several important purposes. First, they preserve testimony. If someone changes their story later, the deposition transcript can be used in court. Second, they test credibility. How someone answers questions calmly, carefully, defensively can influence how the case is viewed and how negotiations proceed. Third, depositions are a critical trial preparation tool. They allow attorneys to see in advance exactly how the opposing party or another witness is going to answer questions. That helps us prepare for cross-examination, anticipate arguments, and refine trial strategy. There are fewer surprises when someone has already testified under oath at a deposition. And finally, depositions can often move cases towards resolution. Once both sides hear the sworn testimony, strengths and weaknesses become clear. Many cases settle after depositions because everyone has a more realistic picture of how the case will play out at trial. Now, preparation makes all the difference. Before any deposition, I meet with my client and go through the likely areas of questioning, the themes of the case, and how to answer clearly and effectively. There are some simple but powerful rules. First, tell the truth. Answer only the questions asked. Do not volunteer extra information. If you don't know or don't remember, say so, and pause before answering. A deposition is not a debate. It's not a chance to argue your case. It's a controlled question and answer process. The biggest mistakes I see are trying to win the deposition, getting defensive, guessing instead of saying, I don't know or I don't recall, talking too much, or arguing with opposing counsel. Short, truthful, precise answers are usually the best answers. So depositions sound intimidating, but with proper preparation, they're very manageable. If you're facing a deposition in a Connecticut divorce case, the key is preparation, strategy, and staying composed. When handled correctly, a deposition can actually strengthen your case and position you more effectively for settlement or trial. So if you have questions about whether a deposition makes sense in your case or how to prepare for one, feel free to reach out. Or if you're looking for representation in a divorce or family law case here in Connecticut, we would invite you to contact our office as well.